I became a painter because I wanted to raise painting to the level of poignancy of music and poetry. The poignancy of Mark Rothko's aspiration ended in the tragedy of his suicide in 1970, but a greater irony was yet to come. The work he left behind, whose subject has been described as the sublime, is now the battleground in the longest, costliest, and most sordid trial in the history of American art. Since 1971, the Rothko case has produced 4 lawsuits, involved 19 lawyers representing 7 sets of clients, and logged in 15,000 pages of testimony. At issue in the present trial, now in its 9th month, are charges by the artist's heirs and Attorney General Lefkowitz that the executors wasted the assets of the estate by selling paintings in bulk to the Marlborough galleries. These same executors, as officers and client of Marlborough, are further accused of self-dealing, and the trial drags on into its last weeks. Since my sculpture, 17 H's, painted cadmium aluminum red, during the process of sale and resale, has suffered a willful act of vandalism, I renounce it as my original work and brand it a ruin. Possibly we should start an action for protective laws. Thus, David Smith wrote an outrage to the editors of Arts and Art News in 1960, 5 years before his death. The heroic poet of steel has become the most prophetic witness in a recent controversy, once again involving the alteration of the sculptor's painted work. The defense is based on a stylistic judgment. Smith's executor, art critic Clement Greenberg, feels that the painted sculpture represents a deviation from Smith's greatest medium of expression, polished steel. Acting on this belief, Mr. Greenberg ordered the removal of white paint from a number of the steel constructions and allowed others to be eroded by the weather. In still another case, a verdict expected this month will end the 3rd and last round of hearings in the estate of David Smith versus the IRS, an ongoing dispute since the sculptor's death over tax assessment. Smith sold next to nothing during his lifetime. His heirs can expect a tax bill based on the government's $2.5 million evaluation of his unsold works. Mark Rothko and David Smith are 2 of the undisputed titans of American art. The questions raised by their cases are not aesthetic. They are legal, moral, and finally historical. Here to sort out some of the issues with us tonight are Palmer Wald, formerly with the State Attorney General's Office, now Secretary and General Counsel of the Whitney Museum; Rosalind Krauss, critic, art historian, and author of a prize-winning study of David Smith; and sculptor Louise Nevelson. 2 of these cases raise serious questions about the role of the IRS, which, as Robert Motherwell said, treats a work of art exactly like a lot of real estate. Both must be converted to cash for tax payments. Beside the Smith estate case, there's the very significant fact that in the Rothko case, an early defense of the executors against charges of dumping the paintings was the need to raise cash quickly for taxes. This line, as it happens, didn't stand up long in court, but it highlights the IRS's role as an agent of dispersal. So I'd like to ask Palmer Wald whether moving from a law enforcement agency to a museum has changed your view of the IRS in questions of artistic patrimony.
I'm not sure my view of the IRS was ever the highest. I mean, there's an obvious problem, is that for the value of an estate or of anything else can only be expressed in terms of money in our system. The government has an obligation under the tax laws as presently written anyway to collect a proportionate amount of the value of the estate. The only way it can be done is to express it in terms of money, and you have to evaluate works of art as you do, as Motherwell says, as you would evaluate lots, as you evaluate shares of stock, as you evaluate anything else.
Well, you have just been named cultural commissar. Would you remove works of art from IRS jurisdiction?
That's one possibility. I mean, you could say, for example, that a work of art will have no value in an estate, or will have a minimal value, much as you say to an artist that the value of a charitable gift that you make of your own works has only a limited value, only the value of the material put into it. That only postpones the determination of value. Once it's out of the estate and in the hands of the heirs, or in the hands of the charitable corporation, if that's the case, then the question of value may well arise. I'm not sure we can ever totally, in our economy anyway, do away with the valuing of works of art on a dollar basis.
Is there any advantage to the artist incorporating or becoming a foundation? Because it seems not to have helped the Rothko estate, but rather to have muddied the waters.
Well, that presents two different issues, really. I mean, the question of incorporation is what the advantage to the artist during his lifetime, leaving aside the charitable aspects. Forming a foundation has been one way of saving on taxes. You form a foundation for charitable purposes. You are able to make donations to the foundation, at least you were in the past, and you could get a deduction from your income tax. The whole question of foundations has been changed as a result of legislation in 1969. The question of incorporation is a very complex one, and I guess for some people it's advisable, others not.
Do you think there's a case for governmental schizophrenia, of which it probably wouldn't be the first instance, the national endowment giveth and the IRS taketh away?
Yes, I suppose there is. But again, so long as we are going to evaluate, so long as works of art are a part of the medium of exchange, so long as they are bought and sold for their financial value rather than their intrinsic artistic worth, the problems are going to exist.
The painter Thomas Hart Benton, now at 85, one of the most senior members of the artistic community, said recently, "The feds have got it now so that by comparing me with market values, they make me a multimillionaire on paper, and I've got to pay taxes for which I've no money. The best solution for me would be to destroy all unsold works before I die." Louise, Nevelson, do you share that bleak viewpoint?
Well, in a way I do. In my own case, I know that it was many years, I figure it was about 30 years, that I was making the work. I never sold anything, which means that now, if I shall die, when I die, much of that work will be under this, what do you call it, taxes. Well, isn't it ridiculous for all that time putting money into making the work, and now at this moment that I would have to pay taxes? I don't really think that you can judge and tax artists the same way as you do commerce. I really don't, because sometimes it takes so long for an artist to develop. Now, that isn't true of business or any other thing. So I think there should be a leeway where the artist can be taken care of individually, because there aren't that many that are going to have big estates that are left.
Where the work in his lifetime and the length of time it took would have some bearing on the estate valuation.
Exactly.
Ideally, what would you want to see happen to your works not already in public or private collections?
Well, in my case, I feel that this is an interesting thing, because you are now with the Whitney. The Whitney has a great deal of my work in depth. And what they don't have, I'm hoping that they will have in time. So I feel secure. That right there, I feel secure. And by the same token, for instance, I have never been shown at the Guggenheim. Well, I'm not going to leave it to the Guggenheim, that's for sure.
That's nice to hear.
As an art historian concerned with 20th century art, Rosalind Krauss, do you think the idea of national patrimony is outdated or provincial? I could ask you that too. I mean, would it disturb you, for example, to see your work end up in Saudi Arabia? I mean, do you think there's a case for keeping contemporary art within the national domain, not destroying the integrity of an estate?
I think that it's terribly important, and I speak not only as an historian but also as a critic. I know that direct contact with the work of an artist of a previous generation is very important for young artists, and repeated contact, the kind of contact that one has when one goes into a museum or into any place where the work happens to be shown and sees it suddenly anew. And that sort of new, fresh encounter with the work of art really does depend on the work of art being there and not simply being something that one sees through reproduction. So I think that for the viability and the vitality of the development of art for people working now, the specter or the possibility of the dispersal of the estate, because it has to be sold in toto in order to pay taxes, is a very grim one, a very depressing one.
Coming to the thorny role of the executors, who play a very murky part in several of these cases. In a landmark decision on fiduciary trust, which I don't have to explain to Palmer, Justice Cardozo stated that the morals of the marketplace will not be used in this area. But since executors in artist estate, as in all others, receive a 3 to 5% interest on works of art sold, isn't that a built-in conflict of interest?
Well, probably, but I think that, well, conflicts of interest are in the nature of things. Judge Madonic, who was the judge trying the Rothko case, said one day when I was, one of the few times I was there, he said, husbands and wives forever put their spouses in a conflict of interest whenever they leave children. A man dies, leaves children, and leaves a wife. There's an automatic conflict of interest between the wife and the children. That's a state of facts, that there is a conflict of interest. The problem is what happens as a result of the conflict of interest, and that I guess is the crux of the Rothko case as it's being tried. What the allegations are that the ones with the conflict did with it.
But I mean, when there's a profit motive for the executor, as there will be, how does this work against the sense of protecting the integrity of the state, or in the question of the Smith alteration, which some have alleged that there is a factor of saleability in the alteration of those works, so that I'm just questioning whether it isn't really built into the situation, a profit and a protectoral role as executor in an artist's estate?
I think it is built in, and you then, I suppose, have to depend upon the ethics and good faith of the executor involved. I don't think you can ever legislate ethics or morality into the situation.
Well, what does the law entitle an executor to do whatever he pleases with a work of art unless otherwise specified by the will? I mean, that I think is
well,
very...
here's an area where I think it may be somewhat murky. The question of, well, the basis of judgment of an executor's duties is what he does for the beneficiaries of the estate. His fiduciary duty is owed to the beneficiaries of the estate, leaving aside those cases, for example, where charities are involved. Mm-hmm. The Smith case is a case where it's just the executors and the trustees and the beneficiaries. Again, generally speaking, the basis of judgment on how well a fiduciary acts with respect to his beneficiaries is how much money he has made. That's the
morals of the
rule.
marketplace. I mean, there's my question coming back. Going to the case of the Smith alteration of the works, Rosalind, do you believe that the alteration of a work of art is ever defensible?
I think the alteration is never defensible. Obviously, there are cases where works are changed slightly. That is, if one considers the removal of a fresco from the wall on which it was painted and the context for which it was painted, if you consider that an alteration of the work, and you do that, removing it from that wall, in order to preserve it, let's say the building is going to fall down, and so the only way to preserve it is to remove it.
Well, that comes under conservation, will it not?
That is an effort to conserve the work. I think in every case where museum people or art historians would sanction touching the work in any way, it's always to preserve the work. It's never to alter it. And the thing that's terribly distressing, I think, to me and to the art community as a whole, with the Smith business, is that these were alterations that were obviously taken directly against everything one knows about Smith's own wishes for his own work.
What about you, Louise? Would you ever sanction the alteration of a work?
No. I would, first let me say that when in my will, naturally I've left that to my son, who's a sculptor. So there's only one person really involved there. And then the Whitney, and I feel this way, that if a work is in any way disturbed, anyone has a right to fix that. But as a work stands, no, I think that is the worst thing that I can think of. But I would, and do intend to put that in my will, that it is not to be touched.
What can the law do, Palmer, beside the artist putting something like that specifically in the will?
Well, I don't know, for example, if the law offers, in the way American law is presently written, any protection for the aesthetic quality.
On the aesthetic quality we must end, and I thank you all very much.